South Carolina's Supreme Court says the state's Fetal Heartbeat Law cannot be enforced, ruling today it violates the state constitution. That law banned most abortions after about 6 weeks, allowing limited exceptions past that point.
State House reporter Mary Green is in Columbia with the details.
Yes, Greg, Judy, this ruling today means that abortion remains legal in South Carolina before about 20 weeks into a pregnancy. Again, the law that the state Supreme Court just struck down today would have limited that to around 6 weeks into a pregnancy, a time that critics argue many women don't even know they're pregnant. Now, the timing of today's decision also comes less than a week before lawmakers are set to return here to the State House for this year's legislative session, and likely try to change South Carolina's abortion law again.
There is no question that abortion is legal and protected in South Carolina.
In a 3-2 decision, the South Carolina Supreme Court ruled the state's 6-week ban on abortion violates the state constitutional right to privacy, finding that right extends to a woman's decision to have an abortion. Justice Kay Hearn, the only woman on the 5-person bench, penned the majority opinion. She wrote, quote, 6 weeks is quite simply not a reasonable period of time for a woman to know she's pregnant and then to make a decision about ending that pregnancy.
The state Supreme Court decision today was remarkable. I'm ecstatic. I think this is a victory for women across the state.
The state's Republican leaders criticized the decision today. Governor Henry McMaster said the Supreme Court had exceeded its authority in this decision, and House Speaker Merle Smith said South Carolina is left with a decision that is not reflective of our state's political process or will.
The legislature makes the laws, not the South Carolina Supreme Court. If the Supreme Court justices want to make laws, they should run for office.
Justice Hearn also wrote in the majority opinion that the state does have the authority to impose restrictions on abortion if they're reasonable, saying the right to privacy is not absolute. Lawmakers will return to the State House on Tuesday, with Republicans holding a majority in the Senate and now a supermajority in the House.
I think we have the will to not let this stand in our legislature, and that we're going to make sure one way or the other that our laws are enforced and they're not undermined by a different branch of government.
Democrats vowing to fight these bans expect it to continue into the new legislative session as well.
I would be surprised if we did not also have another bill filed.
And today's ruling is noteworthy well beyond here in South Carolina. Since the U.S. Supreme Court overturned Roe v. Wade last June, abortion providers in multiple states have taken this approach of suing in state court and arguing that restrictive abortion laws violate rights in their state's constitutions. Today's ruling here in South Carolina is the first final ruling by any state Supreme Court in the country on this matter. Reporting live from the State House, Mary Green, WS News 10.